Artificial intelligence will disrupt the legal industry. When I say disrupt, I don't mean job cuts and payoffs. I mean radically changing an industry which comprises of 20 लाख वकील, 20,000 जजेस और ऐसे कितने सेक्रेटेरियल लोग जो कोर्ट में फाइलिंग करते हैं और फोटोकॉपीज बनाते हैं, सेट्स बना के अलग अलग जगहों पे देने जाते हैं. उससे पहले we discussed the impact of AI on the legal industry. Here is an interesting case where a monkey was denied copyrights to a photograph that he had clicked, famously known as the monkey selfie case of Naruto versus Slater, जहाँ पर एक मकॉके ब्रीड के मंकी ने एक वाइल्ड लाइफ फोटोग्राफर का कैमरा खींच के एक फोटो खींच लेती. And funnily, the photo turned out to be a very decent picture. Now, the organization PETA tried to litigate the case, saying that the monkey was in fact the author and not the cameraman, and therefore the monkey had certain rights to the photograph. The courts pretty much universally said no, the monkey cannot own the copyright on the standard principle that nobody other than a human being can own a copyright, just for the purposes of the Copyright Act. And the answer is no if you're thinking that whether a computer can also own a copyright in the first place, at least not for the time being. So technology की वजह से such complex questions do keep coming to courts every now and then, and we are not there with an answer because the principles certainly get punctured. Now with AI, the question is that should AI be able to get a copyright over the work that it produces? What would that even mean? And if the AI doesn't own the copyright, who owns the copyright? The guy who created the image with the help of the AI, or the guy who created the AI software to create more things? Even better. And what about training an AI using someone else's work so that in the future when it's asked to produce more art, it creates almost similar forms of art inspired by other artists who have uploaded their pictures, their songs to a particular platform? तो ऐसे जबरदस्त questions आते रहेंगे कोर्ट के सामने because there is a new way to produce work now, and it's going to get only interesting from here because jurisprudence is clearly not ready to handle all this. Coming back to the topic at hand, whether AI will become a lawyer or not is only something that time will tell, but before it does or it does not, there are three very important things to keep in mind. Number one, failure of AI to deliver legal requisites such as disclosing information or putting out a document which is a legal mandate under the relevant law, but in the process of case strategy, the AI just fails to do that. Now what that means is that AI, while doing a prosecution, deems fit that in case strategy it is not important कि accused की movie tickets उसको case में लगानी चाहिए थी या नहीं लगानी चाहिए थी. नहीं लगाने से it makes the case stronger because now he doesn't have an alibi for the matter. AI in its fine judgment just doesn't attach those movie tickets, which falls out of the legal mandate. Number two, criminal and potential offenders will also have access to AI technology so that they can strategize their crimes like that. A murderer will be able to know how to murder, when to murder, so that he can evade conviction. A drug dealer will similarly be able to make a supply chain in which there is minimal chances of getting caught. And thirdly, the most important and the most complex problem with AI taking over the legal world is passing off inherent biases that have been there in the data set being passed on to create future documents which will also contain this. Now this is a complex one, and for which it is important that how you understand that how an AI works. An AI works on the basis of data sets that's been fed to it. Judgments, contracts, prompts, specific forms like charge sheet, FIRs. Now in all these FIRs there will be authors such as policemen, such as lawyers, such as judges जिन्होंने ये forms, documents लिखे थे. And in this there's a lot of human bias of caste, gender, creed, sex, etc. So let's say a lot of judgments are fed to an AI. So let's say there is a judge who has a habit of convicting everybody who's a Muslim. Now the AI will be trained on this data set where all the Muslims will be convicted, and accordingly that bias will get passed on in the judgments written by the AI, where people who will be from Islam will be more likely to be prosecuted in comparison to any other person who's from a different religion. And yes, these are very real questions with the times when AI is taking over pretty much every space of our life as we proceed. Well, we're going to explore all of that today, and whether an AI can own a copyright or not is also something on today's docket. And usually when I'm answering a question as a lawyer, a lot of it is whether or ifs and buts, and only then I say that maybe not, because it's as grey as possible. In the case of an AI, I can very clearly say no, that is not the case. An AI under the current law cannot own copyright in the work that it produces, because copyright is reserved solely for human authors, and under the Copyright Act, the only thing that can get a copyright to an original work has to be a human. The additional issue while considering whether a copyright can be granted or not is the element of creativity and minimal effort. And that is the threshold that is considered while granting copyright, that कुछ भी बनाने में आदमी का कुछ भी मेहनत लगा है, creative था, expressive था, and only then copyright is decided. You see, like that's the difference between a child throwing a paint on the canvas and saying that it's my work of art, and Picasso, who would have spent months or even years on a specific painting, putting his effort out. Who do you think has a better chance of getting a copyright in this scenario under this principle? And this wasn't really always the case, considering the cases of photography. Photographers weren't always considered as artists, and photography wasn't copyrightable all the time. The case dates back to a 19th century case of Baroguy's lithography versus Sorony, in which it was cleared by the court that a photograph has customizations available. Earlier, while it was considered that a photograph is a mere reproduction of what the camera sees, now with more customizations available, a different setting in ISO settings, shutter speed, an exposure triangle and other things, you can change the way a single camera is clicking a picture at the same point of time with different settings. And these customizations translate to a minimal level of creativity and effort being put into reproduce a certain work of art. And therefore, photographs are now copyrightable. And when it comes to AI generated work of art, it's very likely that the court will say that it's not copyrightable because simply the computer did the work and you did not really put in effort or creativity into producing that work of art. And now there have been instances where a lot of people are creating art, such as articles, from pictures to songs on the internet with the help of AI technologies, and also have tried to get it copyrighted. And while this is something new that is happening in India, it has been going on for long in the United States and other technologically advanced countries. In one very interesting case, एक बंदे ने AI की पूरी मदद लेके एक पूरी comic book बना दी थी. He used ChatGPT to create an entire story, and after he got the story, he fed that to DALL-E and Stable Diffusion and was able to extract out comic book pictures. And thereafter, he applied to the Copyright Office saying that this is a copyrightable work of art. While he did clarify that he used AI technologies, and the Copyright Office did give him a copyright in the first place, but now realizing that AI was used to create that work of art, the copyright is now trying to deny him his copyright and rescind that intellectual property protection. Now see, this isn't a binary dichotomy. It's not like एक जगह AI से काम होगा और एक जगह इंसान से काम होगा. It's a spectrum. On one hand, you have something that is truly generated by an AI on its own, and on the other hand, you have something that's truly developed by a human being without the help of any AI software. And at this moment, it's very unclear at what point will court say to AI generated works of art that hey, that's enough human creativity in there to call it copyrightable. For example, I can imagine that I click a picture of me right now sitting like this, and then I do a content aware fill on a certain part of the wall which has a painting. Now the photo is edited with the help of an AI software and clearly changes the work of art. And बहुत सारे तरीके हैं जहाँ पे लोग AI use करके अलग-अलग चीजें बना रहे हैं. And at the moment it's very unclear as to at which point the court will interfere and say that hey, that involves effort and creativity and therefore it's copyright. This is going to be litigated in courts for the times to come, and a lot of judgments are going to follow whether AI can get a copyright, whether AI can infringe a copyright, and similarly all venues of intellectual property, and in fact all laws altogether, where the involvement of AI is going to radically change the jurisprudence of how things have been practiced until now. But a lot of people are upset about the way AIs are trained, and we have seen several instances that if you train an AI on a data set of a particular author or a painter's work, the AI does a pretty good job of being able to replicate the style of that artist's work and create new works of art in that original author's style. The funny part is you can't get a copyright over a style of painting or a style of music or any style of any creation that you do. What you can get a copyright is in a definite form of work of art, which can be protected under copyright and therefore cannot be replicated, etc. But is it fair or ethical or legal to be able to train an AI using a dataset that includes copyrighted work? Because it seems that like most AIs are pretty much useless until they have been trained on a very large dataset, and usually that involves scraping millions and millions of pictures of the internet, of Google, of Getty Images, of Shutterstock to be able to build Stable Diffusion, which actually happened in this. And before you wonder that using all these billions of images that an AI takes from the internet, is it copyright infringement? Well, yes, it is, and it is actionable in the first place. And while reproducing someone's work and taking it from another area of the internet and putting it on a data set is often going to involve what would technically be considered copyright infringement, but it doesn't really end the analysis over there, because even though something might be considered copyright infringement, the purpose of it being scraped off the internet and put in a data set under fair use can certainly take away the liability to a greater extent. The two cases in this scenario are very interesting, one being the Perfect 10 versus Google case. Perfect 10 being a website which sells photographs for a good amount of money. Now you can imagine internet पे लोग ज़्यादा पैसा देके किस टाइप की पिक्चर्स ही खरीदेंगे. And while Google was just doing something that it does, it was using the pictures as thumbnails as an introductory on their search algorithm, and Perfect 10 sued Google saying that these are works of art and protected under copyright and you can't use them as thumbnails. Courts went the other way and saying that, hey, this is not reproduction of work and it is being used for a different purpose altogether, and therefore there is no copyright infringement. And similarly in the second case of Google Books, where ओरिजिनल ऑथर्स जिन्होंने काफ़ी मेहनत करके अपनी बुक्स लिखी थी, अपनी बुक्स को जब वो गूगल बुक्स पे देखते हैं और दे कैन सी दैट विदाउट हैविंग टू परचेज अ बुक पीपल कैन गो थ्रू एक्सर्प्ट्स ऑफ देयर बुक्स, they were terrified and they sued Google over copyright infringement, saying that hey, Google is again reproducing their works of art and not giving them any money for it. Well, we can all guess where the courts went. Yes, the court ने सीधा बोल दिया that the entire book is not out there. In fact, the search algorithm is just using the books to highlight what a person is trying to find at a point of time, and therefore there is no copyright infringement. And that is intellectual property law and technology not being in sync with each other. And the analogy of fair use breaks down in these two cases, and therefore new jurisprudence is made where just putting out somebody else's work in a different format under the guise of a search algorithm changes the answer of whether it is copyright infringement or not. AI is different. AI is not just search algorithms like Google. AI is generative. वो अपनी पेंटिंग, अपना गाना, अपने beats खुद बना लेता है. We don't entirely know what the court is going to decide when it comes to true AI generation of work based on a data set. The same kind of fair use defense Google might have in a descriptive context might not apply to AI generative context. See, the arguments on both sides are pretty good. एक कह रहा है कि AI is pretty similar to what Google search is doing, and one might also argue that AI is doing what every single human being in the world is doing. They're experiencing art in their own world and then reproducing on the basis of it. And while that does form the basis of the history of mankind, that everything is at the center of our experiences, and anybody who creates art only is able to do that after absorbing in arts from everywhere in life, then he is able to manage to somehow reproduce a painting or compose a song or any other thing whatsoever. The only possible solution that I look at it is that it has to be solved statutorily. मतलब लोकसभा राज्यसभा में एक लॉ पास करना पड़ेगा जहाँ पे काफ़ी क्लियरली लिखा होगा that any work of art generated by an AI is not copyrightable, and only human beings have the sole right to own a copyright over any work of art. And that takes us to the most strangest situation, the way we were discussing that an AI can't have a copyright in a work that it generates, and it's likely that the people who program the AI, even they won't own the copyright in the first place. But that doesn't solve the issue of copyright infringement, you see, because just because you don't own a copyright in something doesn't mean that you can't commit copyright infringement. For example, let's say I ask an AI text-to-image generator that I want a cartoon of a mouse wearing red shorts, and it happens to produce a photograph of Mickey Mouse. I didn't ask the AI to produce Mickey Mouse, but still there is a copyright infringement because all the data sets of mouse wearing red shorts was Mickey Mouse that the AI had known until then. The interesting fact is that I probably don't own the copyright for Mickey Mouse, neither does the AI generator, and yet there is infringement going on the copyright of Disney because it looks exactly like Mickey Mouse, which raises a very important question that who's liable for this copyright infringement now? It's sort of anyone's guess. Copyright infringement tends to be a pretty strict liability offense. Theoretically, maybe the programmer is liable. Theoretically, maybe the person who provided the prompt itself. Certainly, if I were to go and reproduce that image and publish it, then I would certainly be liable of copyright infringement, and it is a strict liability offense. But there's all kinds of unintended consequences that are potentially possible here that we don't necessarily have a good answer for. And speaking of unintended consequences, right on schedule, the lawsuits have started pouring in. There are several interesting lawsuits testing out these copyright issues in light of AI. The first set of lawsuits are against Stability AI, and companies like Getty, Shutterstock, and other online image databases have sued stability diffusion. And while most of the AI companies are very secretive about their data set and from where did they get this data, stability has been fairly transparent about it. And in one particular scenario, stability produced an image where it contained the watermark of Getty Images as it is. Getty Images officially notified Stability AI of its intent to sue them in United Kingdom for unlawfully scraping millions from its site, which could violate UK's standard of fair dealing. Or Stability AI copied and processed millions of Getty Images to train its software, and whereas most AI companies are secretive about where they get their data, Stable Diffusion is transparent. The open source software allowed Andy Bio and Simon Wilson to analyze the training dataset. They found a large number of images came from stock images sites including 123RF, Shutterstock, Vectorstock, and Getty, among others. And sometimes the AI even recreated a facsimile of Getty watermark. Getty's lawsuit was filed in a High Court of Justice in London, and the company didn't say whether they were going to file a lawsuit in the US. However, in a press release, the company argued that Stability's actions did not meet the standard of fair use in the US. Getty argues that it's the same position in the artist whose music was illegally shared by Napster, and the possible outcome can be very similar to a license agreement, similar to Spotify having one with their artist, which negotiates licenses with its right holders. Meanwhile, visual artists filed a class action lawsuit against Stability AI, Midjourney, and DeviantArt. The three named plaintiffs are artists whose works have been used to train AI models. Sarah Anderson is the creator of the webcomic Sarah Scribbles, and Carla Ortiz is a concept artist and illustrator who worked for Marvel Film Studios and Wizards of the Coast. The complaint was filed in California, and it alleges that the three companies committed copyright infringement by using images owned by the artist to train the image generators and produce derivative works. The plaintiffs also assert claims under the DMCA in fair competition laws. Now, only the copyright owner has the right to make and authorize an adaptation of the original. The plaintiffs claim that the image generators are simply 21st century collage tools that enable users to make unlicensed derivative works, but that seems like an oversimplification. But who knows what kind of analysis the court might use to pass and understand this new technology and its implications. It's an open question whether the generated images would qualify as derivative or not, and there are good arguments on either side. See, the important thing is that AI is changing the way that we have interacted with technology and other things around us. Right from being able to pick up a pen and paper, write an article, to going to the art store to buy a lot of watercolors and paintbrushes, to paint on a canvas and have a beautiful painting, to be able to sit down and play your tabla ताकि तुम एक अच्छी धुन निकाल पाओ. AI is changing the way art has been created till date, and now all you need to do is just sit on a computer, enter in a few prompts, and have the works of art automatically being created to you. And until now, copyright issues were decided on an image-to-image basis, but now in the Anderson vs. Stability lawsuit claims, quote, when used to produce images from prompts by its users, Stable Diffusion uses the training images to produce seemingly new images through a mathematical software process. These, quote, new images are based entirely on the training images and are derivative works of the particular images Stable Diffusion draws from when assembling a given output. Ultimately, it is merely complex of a collage tool. Now, this is the section of the plaintiff's complaint really gets to the head of the argument. The plaintiffs are claiming that everything generated by AI is a derivative, and now a derivative work is an independently copyrightable work that is used. So, for example, compare the movie Jurassic Park to the book Jurassic Park. The original novel had a copyright. Michael Crichton had a total control over the novel Jurassic Park, and also Steven Spielberg had to get a license from Crichton to make a movie which was a derivative work. Now, the technical definition of derivative is, quote, a work based upon one or more pre-existing works such as translation, fictionalization, motion picture version, sound recording, art reproduction, abridgment, condensation, or any other form in which a work may be recast, transformed, or adapted. Now, notice the Copyright Act says a derivative is transformed. Now, this can get very confusing because if you know anything about fair use, transformed or transformative, it's basically the same standard. Now, the movie Jurassic Park definitely transformed the original novel, but that doesn't mean it's necessarily a fair use. Quite the opposite, in fact, and for the affirmative defense of fair use to apply, it has to be transformative at a minimum, but it also has to have a separate purpose that the courts recognize as allowable. It also must meet the other four fair use factors, and it also gets more complicated from here. As one commentator puts it, the term derivative work in a technical sense does not refer to all works that borrow in any degree from pre-existing works. A work is not derivative until it has substantially copied from prior work. What is borrowed consists merely of ideas and not the expression of ideas, and even though the work may have been in part derived from prior works, if it is not a derivative work, And as one quote put it, in truth, in literature, in science and in art, there are and can be a few, if any, things which in abstract sense are strictly new and original thought. So these are the kind of complex questions AI is posing to the intellectual property rights community, who are so concerned about the existing jurisprudence on protecting works of art, to now a new technology that is producing way too many works of art that can be copyrighted in the first place. And before we head to singularity and everything is controlled by an AI which does keep pushing itself, let us dial back to the present reality of how AI can change the way law is practiced. In law, there are several factors which are minimally requiring any effort or creativity on a daily day-to-day basis. So far as the petitions that we file in court have to be filed in a very specified format. The legal requirements of putting in the relevant facts, the legal jargon of ingredients that are essential to prove any crime or any legal transaction is something that a lawyer fairly does on a routinely work and relies on his juniors to do on a day-to-day basis. All that can be put into an AI generative software which is able to not just draft for you but also file the same in court before the right court with the right jurisprudence, with the right formats, having probably zero defects in it in comparison to us lawyers who probably have 4 to 5 defects in any case that we file before the High Court or the Supreme Court, and similarly, etc. All the secretarial work also stand on the brink of being automated to a great extent, जहाँ पे आपकी मीटिंग से लेके आपके कॉल्स, आपके क्लाइंट्स के इनवॉइसेस, everything become automated again. And now you are relying on a software to do all of this work for you while you can still focus on the art itself. With that, I'd conclude AI taking over the legal industry, and my clear answer is that no, it's not doing it for the people who are fairly new and creative with every approach to life on a daily basis. But so far as doing repetitive and menial work on a day-to-day basis to earn your bread and butter is concerned, yes, AI is coming for you. If you like the content, I'm going to be definitely putting out a lot of technology-related content and the use of AI and machine learning and the legal practice. Stay tuned for more and do let us know what you think in the comments below. With that, Vakeel Lane out. Yep.